A diagnosis changes everything. If you have a loved one or a child diagnosed as being on the autism spectrum or having a special medical condition, that moment, your world changes. You have to start thinking about not just supporting a loved one or a child, but providing that support maybe for the rest of their life. We can relate to this. We hear it from our clients all the time. So now let's talk about the key tool that you need to have in place, a special needs trust. That is the first step you should take. If you face this, and if you don't have it yet, that's okay. Let's get that into place now. But Mike, why don't you talk about what special needs trusts are in plain English and why they're so important?
The question is, how do you take care of your kid if your kid has special needs? In other words, has a problem with getting and maintaining employment to make a living, which in turn can generate eligibility for government benefits that can be extremely important. So the idea here is, in a way, it's really simple. It says, let's set aside a whole lot of money to take care of your child, but just make sure that we do it in a way that it doesn't interfere with eligibility for government benefits, income programs, health insurance, housing benefits, etc. So the bottom line is that any amount of money can go into a properly designed special needs trust. And all of it sits there for the benefit of your child, the beneficiary, but none of it counts when determining eligibility for government benefits. It's magical. It's necessary. It's a critical ingredient. And that's why, as Mark said, and as we constantly say, if you have this issue in the family, the first thing you need to do is to make sure that you understand this trust, create it, and then take steps to be sure that the balance of your plan, as we'll talk about in a minute, that the balance of your plan is coordinated with it so that it serves properly when you pass or if you're no longer able to manage assets for the benefit of your child. It's an irrevocable trust. You have to have the right trustee. We'll talk about that a little bit more. But again, it works. It's tried and true. We have done hundreds of these trusts. And there is a fundamental approach that we take, but often the language of the trust depends on the nature of the disability. So there's no one form. There's no one size fits all here.
Yeah, and I always like to summarize it as it's a virtually unlimited pot of money that doesn't interfere with government benefits, as Mike said, and you're naming a trusted third party to oversee it for them. So your child doesn't oversee it. They don't manage it for themselves. They can't be taken advantage of. So it's a hard choice. We'll talk about trustees and that choice in a second, but it's a multi-pronged solution. But now let's talk about how a special needs trust has to fit in with your estate plan, because you can't just create a special needs trust. That's not enough, right? You need to have, if mom and dad don't have a good comprehensive estate plan, special needs trust can be worthless. Because if their assets aren't governed and managed effectively and preserved, well, there's obviously not going to be anything there for the next generation. So mom and dad or whoever you are creating that special needs trust for someone else, you also need your estate plan. So you need to have your updated living trust that would point to the special needs trust. So whatever you're leaving to that child you want to leave money for, or that loved one, goes to the special needs trust. You need powers of attorney. And if you have a child with special needs, it has to be we're not going to spend too much time on that, but the special needs trust has to have some special language to make sure that your loved one can be supported if you're ever incapacitated. So it can't just be a check the box standard power of attorney. You need your own advanced healthcare directive to make sure that someone can communicate for you in a hospital setting if you can't do it. And the key is a special needs trust should not be embedded in your living trust. It should be a separate document. There are a lot of reasons for that. I mean, one, if you want to update one or the other, you don't have to update both every time you touch it, but there are several other reasons for that. But let's just do a simple diagram of how we kind of envision this. So mom and dad have, let's say, a special needs trust for Sarah, and mom and dad want to leave money for Sarah's benefit, but they don't want to interfere with public benefits. Mom and dad have their own living trust. As you can see there, they do not leave money directly to Sarah. Instead, they leave it to a separate special needs trust for Sarah. And by having that separate special needs trust, you can fund it while you're living. You can coordinate with other family members, which we're going to talk about in just a second. And you can update the documents separately, because while special needs trusts are irrevocable, they can't really be changed once they're in place. If there's no money in them yet, you can always just swap out one special needs trust for a new one. So the bottom line is you need to have this in place. It's a lifelong safety net. It's a way to protect a child, or really anybody who needs government, or who might be able to get government benefits and might not be able to support themselves. Special needs trusts can hold property. They can hold stock. They can hold bank accounts. It's pretty flexible what they can hold, but you just have to have that. It can address the lifelong cost of care for your loved one. Any other thoughts, Mike, about making sure people have that whole complete package?
The only point I'd mention is that we're appropriately focusing on mom and dad, the parents of this child. If you think about it for a moment, the vast majority of kids who have special needs, who may not be able to make a living, still can function. They can make some decisions. So another ingredient that's critical, we believe, is for the child who may be 20, who may be 30, who may be 50, should also have in place his or her own durable power of attorney, advanced healthcare directive, and maybe a simple will in the event that they have any assets. We just want to make sure that we never have to go to court to establish a conservatorship, which is usually not necessary, even though many folks have conservatorships in place. We try to avoid them. We only do them when they're absolutely necessary, and we think that's pretty rare. So planning on behalf of and actually by the special needs child or individual, as well as mom and dad.
If your child's over 18, and that's really true for anyone over the age of 18, by the way. Anybody over the age of 18 should have a power of attorney, so someone can step in and deal with their financial issues if they can't, in an advanced directive.
Let's mention when all three of our kids, including this young guy here named Mark, Raphael Gerson Gilfix, when he turned 18, power of attorney and advanced directive. It just makes sense. It just makes sense. You never know what's going to happen.
Yes, I remember when you guys presented me that document, you're like, hey, you okay with this? Like, and I was very confused, but now I'm glad you did it. But when you have estate planning parents, of course you do these nerdy things that everybody should do, but only the kids of estate planners seem to get these in place without a lot of help. Well, we can help with all of this. So let's stay in touch. You can join our Gilfix Law YouTube channel. You can also join our mailing list on our gilfix.com website. Easy to join our mailing list. We at the Gilfix and LaPole team love to have more people in our community. Very easy to find us, gilfix.com. Or contact us at 650-493-8070. Thank you guys so much for joining us. Hope everybody's staying safe, sane, and healthy, and we'll see you next time.